So, Christmas greetings to all of you.
Daily course list, item number 1 for pronouncement of judgment.
To mention one unlisted item.
You should know the first thing that comes in the list is the pronouncement of judgment. Thereafter, there will be mentioned. You are in this case?
Yes, sir. I'm appearing on behalf of Dr. Ann Mozika.
Who's nobody is there on the other side. I'll read out only the operative portion. As has been observed by the learned trial court, the CBI has not been able to clarify as to whether the documents and evidence relied upon at the time the charge sheet was filed are valid or not, or rather as to whether they are invalid, and further, even in this instant case, nothing is said as to whether the material evidence relied upon by the trial court to discharge the accused person are suspicious, and as such, it can be assumed that the learned trial court have found such documents, evidence furnished by the accused person at the time of consideration of charge not suspicious at all. The manner in which the learned trial court has elaborately addressed the issues involved in the impugn order has convinced this court that the same has been passed within jurisdiction and no impropriety can be imputed therein. Consequently, this court is of the view that the impugn order suffers from no jurisdictional error. The same is hereby upheld. Petition disposed of.
Much obliged.
My pleasure, Lordship. I beg to mention, I have filed one matter, Your Lordship. It's urgency is there. However, we give the application, but it hasn't been listed. So I beg to pray before Your Lordship, if Lordship is pleased to hear the matter.
What is the urgency?
With regard to managing committee, what happened, Honorable Justice, thank you, give a direction that within 1 month to reconstitute a general committee meeting. But notice was issued for holding the general meeting on 30/11. That more than 50 people were appearing in the school premises. Suddenly, the petitioner gave a notice at 9:30 the meeting, then that postponed the postponed the election. Thereafter, no election was held. Then on 13, it came to know, on 17, it came to know, on 13, from the education department, they have approved a managing committee. No managing committee, no election was constituted. That is the urgency of the matter.
Why is, those are matter of course.
No, the reason is this.
If you are aggrieved by such action or inaction, whatever the case may be, you can come by way of a regular application.
No doubt, no, because what happened, Your Lordship?
That, and anything that is done cannot be undone.
No, the petitioner who got the order on this honorable court, against him a criminal case is pending. The criminal case is pending, of course, Your Lordship, that is under investigation. So the general public, they feel that again he is becoming the secretary. All evidence will be tampered. There had been a reason, the urgency. I want to move that to stay that approval for the time.
Any application which comes, direction has been given firstly to the registry to check the status of the case, whether they are urgent or not. Eviction bench, as you know, will sit only where very, very urgent matters are, are to be taken up. Now,
and the litigants will suffer. That is the reason, Your Lordship. Therefore, I just want to make the mention. If I can satisfy Your Lordship, Lordship will place.
You take a chance before the next vacation bench. Next vacation bench is coming up on 10th.
Next
vacation bench is coming up on 10th. Just a matter of
on 10.
Few weeks.
In fact, Your Lordship, I only here, I'll be out of station, that winter region.
You can always appear through.
Anyway, if Your Lordship wants. Then it will be listed on 10th, Your Lordship.
No, not necessary. Not necessary to give you. It will be listed since you have filed it, isn't it?
We have filed it.
Then you have mentioned the urgency.
It
will be listed on 10.
We have filed yesterday itself, Your Lordship.
Yes.
Well, we crave Your Lordship's indulgence, my lords, with a similar kind of a situation. The reason for mentioning this matter before Your Lordships today is, my lords, this is, my lords, a matter concerning the income tax. Now, this is in the face of the judgments passed by, my lords, sitting in division bench with Honorable the Chief Justice then, my lords, referring to the Mahari judgment, where Your Lordships have culled out whatever is the law. Now, the reason for mentioning this matter, why the grave urgency is, my lords, there was a notice issued under 148. Now, that time period, my lords, has expired just, my lords, 1 or 2 days back. The difficulty is that the extended time, my lords, is expiring on the 31st of December 2024. Now, post that, my lords, I will be liable for prosecution under the provisions of the Income Tax Act, my lords, whereas in this particular case, my lords, it's actually astonishing that the income tax authorities are behaving in such a manner. There's a loan sanctioned to me by the Meghalaya Rural Bank, my lords. That loan is taken over by the Bank of Baroda. Then Vijay Bank, my lords, then Bank of Baroda takes over the loan officially. That loan is transferred from one bank to the other, my lords. They treat the money which has come from as loan, my lords, as my income. And they, my lords, then are issuing notices initially under 143, then under 148. If my lords kindly take it up, my lords.
Is it income tax or it would be, I think it has to be put up before division bench.
Well, its vacation courts are otherwise invested with powers of division bench, my lords.
But we specifically have I think there's a notification for
No,
constitution.
that is correct, my lords. But vacation bench, my lords, as my lords would be aware.
We'll take it up on the 10th. Yeah?
My lords, my difficulty is, my lords, the 31st. Others, I would not have mentioned this matter, my lords.
Where is it? Have you specifically got received a notification that
Yes, yes.
it expires on the 31st?
31st, my lords. 31st is the last date. That is the difficulty, my lords. Otherwise, I would not have mentioned this matter. We wish, as a matter of fact, issued advance notice to the income tax authorities also.
Matter has been processed through the registry.
No, my lords, the
filed
writ
it,
petition has been registered. We had given a letter of urgent listing, my lords. Unfortunately, it's not been listed.
Again, you see, that would be again be the wisdom of the registry. If they find that it's not urgent.
If I may, my lords, the wisdom of the registry cannot prevail over my lords.
True, but you see, unless the matter is processed in the usual manner, how can this court, take up at this point of time?
My lords, I have explained my eminent difficulty, my lords, because probably this did not, my lords, percolate with the registry. That the difficulty is, my lords, of the 31st. If had it not been the 31st, my lords, it could have probably come at some other point.
You can always approach the concerned authorities and get your relief there.
I'm sorry, my lords.
You can always approach the authorities.
We have, my lords, we have.
Get your relief there.
My lords, we have. The difficulty is they've issued a notice under 148. Now, the difficulty is, my lords, if that period passes, then I'm liable for prosecution. And that is in the face of the law that's been laid down, my lords. It is very unfortunate. As a matter of fact, there's some remarks made by this honorable court in that judgment also, my lords, that this is the authority, this is what has been there for the last 30 years. Essentially, people are, my lords, following that. Now, if that be the position of law, there is no question of me, my lords, being assessed under the IT Act and then issuing a notice under 143 and 148, my lords. Because initially it was a notice under 143, so I could have reverted back to them. Now they've closed that part also.
You prevail upon the registry. If there is that much urgency, then a division bench will be constituted. That is always there. We have Justice Thank you, who's in charge of the administration. He will take up the matter.
My lords.
And perhaps by Monday it can be constituted.
My lords. I'm grateful. Obliged.
On 10th, the Honorable Justice Sajid sitting, but he refused to take up because that is his client.
No, okay.
10th, then
doesn't matter because we will be sitting in division bench.
Single.
And
Division? No, mine.
No, I understand. What I'm trying to say is this: we will be sitting up in division. We will be sitting in division bench, Justice Bhattacharya and me. And of course, it is stated that his single bench will be also be there. If I'm here, then I'll take up single bench matter.
On 10th?
On 10th.
Because otherwise he cannot take up. He refused to take.
If I'm here, I'll take up single bench matter. Whatever comes within my roster, or even if directed by Chief Justice.
Your Lordship, similar thing, Your Lordship, and I apologize for the first mistake, Your Lordship. It's an unlisted matter, Your Lordship, criminal petition 71 of 24, Your Lordship. We had filed for the urgency, the application, but it
We'll
was
take it on 10.
on 10, Your Lordship. Because, Your Lordship, the petitioner is getting transferred and the FIR is not being registered for 2 weeks, more than 2 weeks now.
You see, your remedy is always there. First, you have to approach the magistrate. You have to get an order from the magistrate. Have you approached the magistrate? Have you approached the SP?
Your
If
Lordship,
an FIR is not registered, see, what is the first course of action? You have to approach the SP concerned.
Yes,
If
Your
he
Lordship.
refuses, then you go to the magistrate. I think that's, is it 156?
My lord.
Anyway,
154 clause 3.
As
Yes, but Your Lordship, I'm not asking anything which is beyond the ambit of this Honorable High Court, Your Lordship. This court can obviously interfere and
I don't
prevail
think there's
justice.
urgency there. You prevail upon the registry, matter can be listed on 10 and see.
All right. Highly obliged.
In the meantime, you take those actions.
All right,
You
all right.
Take steps.
Yes.
See if nothing is done, then you have a case before the court.
this law is settled in the case of Shikri, my lord, that is Shikri case, which is a constitutional bench. This particular, my lord, query has been settled there. Let it come and then.
All right, Your Lordship.
Item number 2.
May it please Lordship. Lordship, the brief fact of the case is that this petitioner herein, along with 2 others, my lord, that file a partition suit before the Learned Court of EDC, my lord. So subsequently, my lord, what had happened, the petitioner had given objections before the office of the CM of Meghalaya, my lord, not to, my lord, mutate the patta till such time the suit is disposed of, my lord, decided. So meanwhile, my lord, what happens, the CM of Meghalaya, my lord, they had mutated the patta without hearing the petitioner, my lord. So later, my lord, what had happened, on the last, my lord, on 19th, we had to file a writ petition before this honorable court, my lord, 17th, my lord. So subsequently, my lord, that writ petition was disposed of. If my lord may kindly come to page 16, my lord.
Yes.
What let us file this writ petition, my lord? There were only 3 working days, my lord, before the vacation starts. So, my lord, what happened? We had filed writ petition before this honorable court. So, my lord, this honorable court had disposed of the writ petition, directing us to go before the learned ADC and file an application, my lord. So, what happened, my lord, and directed the learned trial court, my lord, to dispose of the petition by passing appropriate orders, my lord. My lord, may kindly come to page 16. Annexure 2, if I may take, my lord, to page 19, paragraph 4, my lord.
Yes.
May I read, lordship, my lord? May I read, my lord? I have heard learned counsel for the parties and also examined the materials as placed by the learned counsel for the petitioner. The writ petitioner has annexed as at annexure 3 to the writ petition a copy of the plaint title suit number 23T of 2022, which is a suit for partition and declaration of right in interest, and has submitted that it is at the stage of issuing documents. It is also noted that the respondent number 1 in the instant writ petition is also added as pro forma respondent number 6 in the said title suit. This being the situation, coupled with the fact that no materials have been brought on record to show that there is constructions going on in the suit lent, and also due to availability of the alternate remedy, the writ petition is not entered in at present. The writ petitioner is, however, at liberty to approach the civil court where the suit is pending, and a concession is given that on such application being preferred before the trial court, the same shall be taken up and order passed thereon expeditiously, my lord. So here, my lord, what happened, due to paucity of time, my lord, but the photograph at that point of time was not annexed, my lord. So later, when the application was filed before the trial court, my lord, we had annexed the photographs, my lord. If my lord may kindly come to my application is at page 22, my lord, and the photographs which had annexed.
Page 22.
Yes, my lord. 21 is the petitioner, my lord. Petition which I have filed before the learned trial court, my lord.
Yes.
Here, my lord, In this petition, may kindly come to page 25. Page 25. I had annexed the order passed by this Honorable Court. Also, I had annexed the photographs, my lord. These photographs, the clear copy, I have annexed here, my lord.
Page 25.
Yes, my lord. In the annexes, para 9, my lord, I have categorically mentioned. Para 9, my lord. Copy of the photograph is annexed here to and marked as Annexure 5, my lord. The colored print I have annexed before in this, my lord, revision petition is at page 44, my lord. 44, my lord.
Yes.
So this would clearly show that, my lord, the constructions work have been carried out, my lord, during pendency the proceedings, my lord. My limited prayer before this on board, my lord. At least, my lord, the respondents, especially more particular respondent number 3, my lord. Number 2 herein, my lord, in this petition. Other respondents are fine, my lord. Only respondent number 2, my lord.
Yes.
May kindly be directed, my lord, to refrain from carrying out any further construction work.
So
Till such
this
time-
work is carried on by this
Number 2.
respondent two.
Only number 2, my lord. Till such time this application is disposed of, pending before the learned trial court, my lord, he may be refrained from, my lord, carrying any further constructions. That is my limited prayer, my lord.
But your prayer has been rejected by the trial court.
Not rejected, my lord. You should notice. Madam, kindly come to the order, my lord.
notice. But
Yes, my lord.
you have
Madam, kindly come to.
You have brought to the notice of the trial court that this construction is going on.
Yes, lordship. I had annexed the photographs also.
In spite of that, no interim order is.
No, simply, madam, notice was issued. Madam, kindly come to page 45, my lord.
Yes.
May I read the last part, my lord? The last paragraph.
Yes.
It has come to the notice of the court that the matter for partition title suit number so and so is pending before this court. So also the miscase number so and so under 39(1) and 2. Since the counsel for defendant number 3 and 4 and 2 are appearing before the court for the state matters, on perusal of the matter on record, this court deems fit and proper to hear all the parties before passing an effective orders before an effective order be passed. Petitioner to issue notice to all the opposite parties, my lord, and fix the matter on 3/2/2025, my lord. By then, my lord, after construction is carried out, the petition which is pending before the court also would become infructuous, my lord.
Have you even now? So you have to take steps for issue notice.
We'll take justice service, my lord. We'll take justice service, my lord. Other responses, they are okay, my lord. Only response number 2, my lord. He's interfering in the property, my lord.
Heard Mr. Espanti, learned counsel for the petitioner, who has submitted that the case between the parties herein revolves around a suit for partition and declaration of right, title and interest. The same being taken up before the trial court and registered as title suit number 23T of 2022. Along with the said title suit, Miss case numbers 117 and Rocket T of 2022 was also filed. In the meantime, in course of these proceedings, the petitioner has approached this court by way of a writ petition, being number being WPC number 481 of 2024, and this court by order dated 17/12/2024 had disposed of the same, and has directed with the direction as follows. Ainika para 4. Next, the petitioner, being so directed, has approached the trial court with a miscellaneous application under section with an application, no, the miscellaneous, with an application under section 94, read with section 151 of the Code of Civil Procedure, with a prayer for grant of ad interim injunction. It is the submission of the Learned Counsel that as far as the suit land is concerned, the respondent number 2 herein, in spite of respondent number 2, in spite of the pendency of the suit, had proceeded to make certain construction on the suit land. If such construction is not stopped for the time being, the prayer of the petitioner would become futile and the application itself would become infructuous in due course. However, by the impugn order, where is the impugn order?
Well, page 45, my lord. 46, my lord.
By the impugn order, the Learned Trial Court, after noting the prayer of the petitioner, had simply cause for issuance of notice upon the opposite parties therein, and no interim order has been passed for maintenance of status quo, or rather for restraining the respondents, particularly the respondent number 2, from carrying on with the said construction. Next. To buttress his submission, the Learned Counsel had also referred to certain photographs taken at the suit land, the same being annexed herein as at page 44, wherein is shown certain pictures of activities of construction within the said suit land. Next. In the backdrop of these facts and circumstances, the Learned Counsel has submitted that this court may be pleased to, what is your prayer?
My lord, prayer is at page 11, my lord. The interim prayer, my lord, is page 12. To refrain respondent number 2, my lord, from carrying any further
Is to direct
constructions.
the respondent number 2 to refrain from carrying out any construction work in the suit premises till the said application pending before the trial court, being Miss Case number 134 under bracket T of 2024, is disposed of. Next, this court, on consideration of the submission made, at the first instance directs the petitioner to take steps for issuance of notice upon the respondents, the same returnable within 2 weeks. Next, again, on consideration of the submission made as regard the ongoing construction carried on by the respondent number 2 within the suit land, in the interim, it is hereby directed that no further construction work is to be carried out till disposal of the said Miss Case number 134 T of 2024. This matter before the regular bench after vacation.
Deeply obliged.
Item number 3. Item number 4.
Lordship, in this case, I have prepared my affidavit, but affidavit.
He is supposed to file an affidavit showing the status as to how much has been paid.
So this is the.
It's not been notarized also.
I have given the copy.
I've served
Notarized
the
I will be
copy.
given by today itself.
Paragraph 4, Your Lordship, page 3. Page 3, areas of refix pay paid to petitioner 1 to 64. Areas of refix pay process and yet to disburse the petitioner, likely to be disbursed shortly.
So we'll wait.
We'll wait. We'll come after vacation.
Heard Mr. Hardapna Leonard CGC, who has submitted that an affidavit depicting an affidavit detailing the latest status as far as the case of the parties herein are concerned has been filed before this court. At para 4 of this same, para 4 of the said affidavit, the respondent has indicated that the areas of refix pay has been paid to petitioner number 1 to 164. As far as petitioners number 165 to 192, the same is likely to be disbursed shortly, for which the Leonard CGC has sought for some time for the procedure to be completed. Mr. P. Nobri, Leonard Counsel for the petitioner, has no objection to this prayer made and has submitted that this matter, that the petitioner submitted that this matter may be taken up after vacation to allow the respondents to comply with such to allow the respondent
Fully comply.
to complete the procedure, to complete the process.
It'll come on 1st of February,
Accordingly,
first week of Feb.
on pre-mid, this matter on 1st February.
Obliged.
So, Lordship, this affidavit, Lordship, this affidavit I have not, so I can take it and then.
It's not been filed through proper registry, Lordship.
So, don't know what is this? You're
That's
giving
what I've been telling the court. It's been not even notarized also.
Notarized, Your Lordship, this I will be getting right to this. I'll get it. Yes, I have shown this. Yesterday I got so.
I've already dictated my order in those lines. That
Your Lordship can record it as his submissions.
Your Lordship, I'll get it done. I'll get it.
Okay, I'll have to keep my. I'll make the necessary correction.
Obliged, Lordship.
We'll take it as a submission.
Your Lordship.
So this will be in 4 and 5.
Your Lordship.
To go 5, you thought list this matter after.
Obliged.
Item number 6.
Please, Your Lordship.
Yes.
Lordship, these are the two bail applications we had moved, and the CD was called for on the last date, Your Lordship.
Yes, Mr. Khan, what is that?
The status report matters under investigation. It seems like the entered India without documents and they hired a vehicle and so they were nabbed while the purpose was they wanted to travel all the way to Shillong. That's exactly, and the stage of investigation is that they chose to cross the border and then hired a vehicle. After a vehicle, they were planning to come to Shillong. So matter is under investigation at this stage, Lordship.
Lordship,
See, tell me,
yeah.
when they were apprehended, see, I think the last time around, if I recall correctly, firstly, there's no denying the fact that they are Bangladeshi nationals.
Correct.
They had come for the puja, isn't it?
The border was open that day. That is an admitted fact also.
But that is not, the puja part has not come in the case.
Puja.
That part is not there. I was just trying to go through that case, status report, Lordship.
Anyway, whatever the case may be, I just want to be confirmed as to where were they actually apprehended from the border.
Lordship.
Tell me, how many kilometers, inside India were they apprehended? Was it within 10 kilometers or beyond?
Beyond, Lordship. Because they were traveling.
Lordship, they were apprehended in Dauki.
Yes. So that is
more than 10 That is where the temple is.
More than 10 kilometers.
No, Lordship, it is not more than 10 kilometers.
It won't be exact. It won't be more than.
Mr. Khan, if I know you may correct me on this.
Absolutely.
But I'm made to understand that there's as far as the infiltration or the police are concerned, infiltration department for that matter, they have a PIF scheme.
Correct.
I don't know what's the full form of PIF. It's PIF scheme 1962. Within part of the scheme says that if any foreigner is apprehended within 10 kilometers from the border, they have to be pushed back, or rather they are allowed to go back. Whether that was done or not.
Lordship is absolutely correct. In this connection, Lordship, a question came up before the Rajya Sabha, Your Lordship, on this very same issue, if I may humbly submit, Your Lordship. Lordship, the question which was raised by the Home Ministry is whether there is any policy to deport illegal migrants to neighboring countries, that is Pakistan, Bangladesh, Myanmar and Afghanistan. If so, the details thereof and the number of illegal migrants deported to such countries during last 3 years and current year so far. The answer, this is the Minister of State in the Ministry of Home Affairs, Lordship, Sri Nityananda Rai. This is what he answers. Section A and B of central government has been vested with powers under Section 32E and 32C of the Foreigners Act 1946 to detain and deport foreign nationals staying illegally in the country. Under Section 5 of the Passport Entry into India Act 1920, central government may also by an order direct the removal of any foreigner from India who enters India without passport and visa. These powers of the central government have been entrusted under Article 258(1) of the Constitution of India to all the state governments since 1958. Therefore, detection of illegal foreigners, migrants, and deportation to their native country has been a continuous.
Yes, please. Sorry.
Lordship.
Please continue.
Therefore, detection of illegal foreigners. I'm reading in page 2, Lordship.
Yes.
The second paragraph there. Therefore, detection of illegal foreigners, migrants, and deportation to their native country has been a continuous and ongoing statutory process under the Foreigners Act 1946 and the Passport Entry into India Act 1920. Illegal foreigners whose nationality needs to be verified have to await deportation. Till their nationality is verified and travel documents are issued, such foreigners may be detained in a holding detention center by the competent authority of state government or UT administration. Ministry of Home Affairs has issued consolidated instructions regarding deportation, repatriation of foreign nationals to all states and UTs via letters dated 24/4/14 and 1/7/19. A statement related to the number of foreigners deported to these countries by the officials of Bureau of Immigration during the last 3 years, that is up to 31st December 2019, is enclosed, Lordship. These are the number of foreigners. So what I'm submitting, Your Lordship, this is a standing instruction of the central government to all the states that if any foreign nationals, especially with regard to these 4 neighboring countries, where Bangladesh is one, if anybody crosses over to India without valid documents and passport, Your Lordship, the procedure is to deport them once their identity is established. In this case, Your Lordship, these two petitioners before Your Lordship, they are Bangladeshi nationals, and their what is equivalent to our Aadhaar card, that is the national identity card, has also been enclosed as Annexure 1 unit. And that is not disputed that they are Bangladeshi nationals. And the limited period they have is also for being deported to their country, Your Lordship. So this is the established procedure of the government, Your Lordship. And standing instructions are there to all the states that if anybody, they are not to be kept in jails here, Your Lordship, till investigation is there, is because so far there has been nothing incriminating against them has also been reported, Your Lordship. And it is also not denied that the border was kept open on those 2 days for the Kali Puja, Your Lordship. And they were apprehended in Dauki near the temple.
You see, that is your version, that they have come over for the puja.
Lordship.
Perhaps the IO may have a different version, we don't know, because as Mr. Khan said,
True, Your Lordship.
nothing is mentioned here as far as, you know,
True, Your Lordship.
their purpose is concerned. They may be involved in smuggling, they may be involved in, you know, illegal activities for all we know.
Lordship, Lordship, if that was the case, Your Lordship, they were apprehended on 1st November. Today we are on 27th December, Your Lordship. Till date, there has been nothing found against them, and that the CD will reflect, Your Lordship. Because if there was anything, if they were wanted in connection with any case, or they were caught with any contraband substance or anything such like that, it would have come to the notice of the investigating authorities, and they would have reported the same, which is not the case. So the only thing is that then they cannot be just kept here. They have to be deported back to the country of origin.
Yes, the next question, you know, that I would like to ask you is this. As Mr. Paul has pointed out, that was exactly what this court has in mind, whether they have been kept in the detention center, holding or detention center, because that is also, you know, it's statutory.
Lordship, yes.
Because not necessarily that they have to be kept in, you know, in jail custody and all.
Yes.
Whether they have been done so.
Lordship,
no, they are in jail, Your Lordship, in Shillong jail.
So why were they not kept in the detention center?
Because basically, so far state police is concerned, so far without valid travel documents is concerned, Foreigners Act clearly says if there is a violation of 13(2), read with 14 capital A B, the minimum punishment is 2 years, maximum could be 8. Now that provision has been violated. Police have apprehended them and kept in jail because no other things has come out except without valid travel documents. They crossed over in India and they were caught on transit coming to Shillong. So law is very clear on that. 13(2) is very clear on that. If you travel to India without a valid document, it's kind of an offence under the Foreigners Act, and after proper trial you could be convicted with for 2 years or 8 years. So for law is concerned, Lordship, within the four walls of law, police are still investigating the matter. But what my learned friend is saying is something. It's a larger issue. Maybe then.
But if, like I said, if you know, you check and confirm on that scheme.
Lordship, yes.
Lordship,
yes.
Ms. Paul has rightly pointed out. There is a scheme.
There should be.
If that is there.
If that is there.
There is a specific provision under the Passports Act. I can refer to that.
It would not matter. See, if they have valid document or not, as soon as it is confirmed or, you know, admitted by them that they are, you know, Bangladeshi foreigner for that.
They have to be deported.
They have to be deported.
We'll have to check out on that. Yes.
You know, the process would have been. It would have been made easier for all concerned.
All concerned, right? Rightly said, Lordship. Because right now,
keeping them in custody would not.
Right. Absolutely correct. Lordship is correct. But Lordship, here then the BSF, central government may also be made a party so far this case is concerned, because they will be the proper authority to address the issue. They are the first line of defense in the borders as to what is to be done with that. So for Meghalaya police is concerned, Lordship, our parameters are within 13(2) and 14(2). Nothing more than that.
Lordship, the Foreigners Act section 3 is very clear on this, Lordship. That if anybody is apprehended, as your Lordship has pointed out, they have to be kept in the holding area till their identity is established. Here, of course, identity is not even in question, because the FIR itself says that they are Bangladeshi nationals. So, and there is a detailed procedure, Lordship, section 3 of the Foreigners Act.
Yes, what does it say?
3C, Your Lordship, if Your Lordship is kindly. Foreigners Act 1946.
Yes.
3C, Lordship, that they shall not remain in India or in any prescribed area therein, shall, if he has been required by any order under this section not to remain in India, sorry, I'm not, E, Your Lordship, I'm sorry. It's E, Lordship. And if Your Lordship has got it.
Yes.
The E lays down the procedure, Lordship, shall comply with such conditions as may be prescribed or specified, requiring him to reside in a particular place, imposing any restrictions on his movements, requiring him to furnish such proof of his identity and to report such particulars to such authority in such manner and at such time and place as may be prescribed or specified, requiring him to allow his photograph and finger impressions to be taken and to furnish specimens of his handwriting and signature to such authority and at such time and place as may be prescribed or specified, requiring him to submit himself to such medical examination by such authority.
These are all immaterial.
Lordship, this is all the procedure which is to be followed while they are kept in the holding area, Your Lordship. If the identity is not established.
Do we have such holding area or detention center?
Meghalaya, no, Lordship. Assam has it, but Meghalaya, I don't think so.
Why?
As I said, Lordship, then
Meghalaya having such a porous.
Absolutely, it's a very, very porous border.
This is not the first.
This is not the
it is not the first case. See,
we had the other Lordship 2 months back. We had another matter where
exactly
the trial court had granted bail and.
It made me recall that case also.
Yes, and then only on the issue of terms conditions with what should be the bail bond conditions. So, Lordship, this is a larger issue. Maybe if the central government also is a mere party so far this, and they will be the appropriate authority to address the issue.
Lordship, that is why I had referred to the question which was raised in.
Maybe on the next day, Lordship, CGSC can also have an opinion on that.
You implicate the union.
Union of India, because it concerns larger issue, Lordship.
Please do that. As Mr. Khan said, you see, this is an issue which has a very wide ramification.
And my learned friend has realized the matters have been raised in the Rajya Sabha. So it shows that it has got pan-India effect. So any judicial pronouncement, Lordship, should be within the corner of law, so that we know where we stand.
But as I have pointed out, Your Lordship, the central government has already given directions to all the states and union territories regarding this issue, that if any foreign nationals is apprehended within the territory of India, what is the procedure and how they are to be deported, Your Lordship. And clear instructions have been given to each state.
So the state will respond to that. The state will respond to that.
So,
and even if the centre is here, Lordship, we can at least give a quietus to this issue.
As I've said earlier, Ms. Paul, you see,
Lordship,
this may not be a simple matter of, of the petitioner being detained.
Yes.
And the process of, of their trial or charge sheet to be filed and so on and so forth will go on. But if at this instant, again I repeat myself, if the IO comes up with some clear-cut, policies,
allegations against them,
clear-cut procedure of how this matter is to be dealt with,
yes,
in accordance with law,
Lordship is correct. Then
to simplify the matter of their deportation.
Absolutely correct.
That would solve the matter once and for all.
Absolutely correct, Lordship is correct.
Instead of going through the whole process.
Absolutely, very correct. Without those facts being before the court, Lordship.
Even entering to a trial.
Yes.
It may not be necessary.
It may not be necessary. Lordship is correct.
Except for the fact that, as I've said again, if the IO does find something incriminating, against them, that's a different thing.
That's a different issue.
But if they just simply come for such purpose, then matter ends there. But again, we cannot, bypass the procedure.
And that's why
you have a copy of this? Ms. Paul must have given you?
No, not.
We will give a copy of this.
Is this? Are these the two copies given to me? Why did you give two? For confirmation. Give it to
No, but Lordship is right. I think the other issue regarding whether there's a holding area and detention center, why it is not established in such a porous, border, a state which has such a porous border with Bangladesh, and in view of all the current situation, also,
yes.
Your Lordship, I think.
It's quite alarming situation, Your Lordship. So
So not having a detention center and just putting them in jail is also
Your Lordship, we should make an attempt
violation
after
of
the
some human
vacation
rights somewhere.
within first week of
Nothing
Feb.
can be said on record, but you know the situation better than anybody else. So it is, it's incumbent upon each and every one of us.
Every one of us, absolutely.
Diligent.
Lordship.
Ms. Paul, you implete the union,
We'll do that, Your Lordship.
and we'll take up this matter after vacation.
After vacation, we'll make an attempt, Your
Lordship,
Lordship.
that will be kindly taken up on the 10th, Your Lordship.
10th, I won't be there. Please, Lordship.
Lordship, they are languishing in jail for no fault of theirs for last 2 months. Lordship will kindly, and the procedure is for deportation, Your Lordship.
Notice will go to.
Leading to the request of the learned.
If you so desire the matter to be taken on 10, then you file a proper application before the registry.
I will do that.
Registry will decide.
I'll do that.
Otherwise, this court cannot, because I will not be sitting on the 10. It will not be proper for me to impose.
And especially, Lordship, notice has to go to the Union of India, CGSC. So
you take steps.
Their response is required.
Lordship, I'll file an application before the registry, Lordship.
Heard Ms. Paul and Senior Counsel, along with Mr. S.
Argata.
Oh, where's Mr. Oh, there she is. Very peculiar way of appearance. That's okay. Accepted. Along with Mr. Arteta, Learned Counsel. Also heard Mr. K. Khan, Learned PP, who has submitted the status report as far as this matter is concerned. However, in course of submission, the Learned Senior Counsel for the petitioner has referred to, what do you call this, proceedings?
Lordship, what it says is Rajya Sabha unstarred question number 1477.
Has referred to deliberation as deliberation before the Rajya Sabha under the caption unstarred question number 1477, where the subject of deportation of illegal migrants have been discussed. Copy of such proceeding has been produced before this court. The same is hereby brought on record and marked as Annexure X. However, at this juncture, the Learned Senior Counsel would submit that since the issue involved here vis-a-vis detection and deportation of foreign nationals within India, the Union of India is also required to be made a party in these proceedings. Accordingly, as prayed for, the petitioner is directed to take steps for implement of such respondent, implement of the of such respondent. In the meantime, until the appearance of the Union of India, further hearing in this matter is adjourned. list this matter after vacation.
Lordship, kindly, this if it is not mentioned after vacation, so we'll make an attempt with the registry to list it on the 10th, Lordship.
I cannot direct the matter to be listed on the 10th.
No, I'm only praying that because if there's a direction now that after vacation, then the registry will not even consider our request, Your Lordship.
On the prayer of the Learned Council, considering the urgency of the matter, that this matter may be heard in the next vacation bench, this court hereby directs the petitioner to make a suitable application before the registry, the same to be considered as to whether such urgency merits listing of the matter in the next vacation bench. Otherwise, the matter will appear after vacation.
Deeply obliged, Lordship.
Oh, same order.
Lordship.
Keep the keyboard.